Come on, 2, 3.
Well, good morning. Welcome back to the Broadcast Retirement Network. I'm Jeff Snyder. This is BRN AM for Monday, December 13th, 2021. And our top story today, the Supreme Court hears oral arguments for the Northwestern 403B plan case. Well, joining me now to discuss this and a lot more, Kevin Walsh is a principal with Groom Law Group, an employee benefits law firm based in Washington, D.C. Kevin, it's great to see you. Thanks so much for joining us on the program this morning.
Jeff, it's always great being on. It's been an exciting week in the world of retirement law.
Yeah, let's talk about this because there's a famed, in addition to being a famed legal eagle, there's a famous case, the Northwestern case, I think it's called, and it's now before the Supreme Court, and they've heard oral arguments. What can you tell us about this case, and why is it meaningful from an ERISA perspective?
So this case, it's Hughes versus Northwestern University, and the case is a big deal because it's part of a wave of fee litigation, excessive fee litigation that we've seen both in the private sector, ERISA plan, 401k plan context, and we've also seen in the 403b world. Northwestern University offers a 403b plan, which is, with very few differences, it looks a lot like a 401k plan. Mm-hmm. And what's going on is that, we've seen kind of cases like this brought around the country that allege essentially that the investment options inside the plan have fees that are higher than other investment options that could have been picked. Either they're higher than, an identical investment product with a different share class, or they're higher, more expensive than an investment option that the plaintiffs view as comparable. So sometimes this can mean an investment managed by a different manager. Sometimes it can mean a passive fund as opposed to an active fund. But the fees are higher, and that is essentially that the plaintiffs are arguing that that's a breach of fiduciary responsibility.
So
the other aspect of these is record keeping. And, in many cases, or in some cases, the fees that are paid in investment options help offset some of the record keeping costs. So these excessive fee cases can challenge both the investment product fees themselves, but can also challenge, how much it cost, to record keep for the plan.
So Kevin, let's talk about these oral arguments. This is a chance, and you're correct me if I'm wrong, this is a chance for the arguments to be before the members of the Supreme Court, the 9 justices, and they ask questions and they try to kind of get at the different thought processes of both the plaintiff and the defendant, right? The people defending against the suit, right? So what have been some of when you summarize these arguments, what are some of the key themes that you're hearing when you listen in?
Yeah, so one of the great things about the Supreme Court is that it brings uniformity. And part of that process is they wait until there's been a lot of these cases. So, we said there's been a wave of fee litigation, and there's been a wave of fee litigation. We've seen district courts all over the country make decisions on fee cases that have been relatively inconsistent. We've seen circuit courts, which are the courts of appeals, make decisions, and, they're somewhat inconsistent as well. And then the Supreme Court steps in like they have here to put in place a uniform standard across the country. And they wait until they've had these other courts make decisions because it provides them an opportunity to see how other people have decided it, because they'll read those lower court decisions. It also affords them an opportunity to really, wait until the issue all the thoughts have been fully developed. So they'll get briefing on essentially all of the issues in there. And then, really the last step is you've got the litigants counsel on both sides, and they appear before the court, and the court asks questions about from both sides, really to poke holes, to understand, to play devil's advocate, to try to address concerns maybe that other justices have about, how the case should be determined. Now, listening to oral argument, it doesn't always provide a clear indication of what the outcome is going to be. And sometimes you listen to oral argument and then you read the decision, a few months later, and you realize, wow, when that justice was asking questions, they were being a bit of a devil's advocate. They were asking questions that were tougher on the side they agreed with than the other side. So I've got to caution that. Here, I think some of the key takeaways are that the court seemed pretty skeptical of arguments that having too many investment options in a plan by itself would be a breach of fiduciary duty. So the plaintiffs were pointing out, this plan has more than 40 options. Why do participants need more than 40 options unless the plan fiduciaries are trying to, avoid responsibility for picking individual investments? The justices didn't seem to be going for that argument. Some of the justices seemed to think that if there's an identical investment option, so if you've got the same manager with a less expensive share class that's readily available, that if a prudent fiduciary really ought to be picking the lower cost share class if they're identical. We'll have to see how that gets decided. But in terms of having similar options, it seemed like there was a lot more diversity of thought from the bench. Chief Justice Roberts had a great analogy where he was talking about, if I lent him my car, would I expect him to drive to Baltimore from DC to find the cheapest gas? Or would I expect him to, go to the neighborhood gas place or a cheap gas place that he happens to drive by in a typical day? And it seemed as though he was pointing out that if we hold fiduciaries to a standard of they've got to find the cheapest investment option on earth or the best investment option on earth, that's really an unworkable standard. And that what we would expect of somebody who we do have a relationship of trust and confidence with, like if I lent you my car, Jeff, I would have a relationship of trust and confidence, but I still wouldn't expect you to scour the earth for gas stations. I would just hope you came back with a full tank.
Yeah. Well, first of all, if I was borrowing the car, I would just pay out of my pocket and I would put in whatever the car, like if it was 87 octane, 92 octane, or 91 octane, 93 octane, I would just put in and I would just pay out of pocket. But that's what I would do, Kevin.
Yeah, no, I hear that. I think it's an imperfect analogy because I think the fiduciaries don't get much out of running a plan, unlike you would get out of borrowing a car. But I think one of the things is that, Chief Justice and Justice Kavanaugh expressed some concern for the rising number of fee cases. And they flagged some of the difficulties we're seeing in the fiduciary insurance market. So I think the key takeaway here is that we're likely to see, a clearer articulation of how much a planned fiduciary is expected to scour the market, how much they're supposed to, how often they should be conducting fee benchmarking, and whether a planned fiduciary should be viewing a certain number of investments as too many in a planned lineup. So to me, this is great news because one thing about ERISA's fiduciary duties is that they can be fairly, vague and flummoxy. So hopefully after this, there's a clearer standard for what a planned fiduciary should do when they're making investment decisions.
Kevin, before we go to commercial break, just to kind of hit on this a little bit, a 401k plan from company A, even if they're in the same industry, they're all different because pricing, I want to make sure people understand this, pricing is based on the demographics, the average account balance, how people use the plan, meaning the services, right? So it really is hard, and having been in the industry and been on the side of a consultant and done a lot of that work, it's really hard to compare apples to apples. The one question I want to ask you, and you can address that, but the other question I want to ask you is about multiple record keepers. I can think of lots of plans that I've worked in, especially in 403B, that have had multiple record keepers. Serves a purpose for some of those plans.
Yeah, I think that's accurate. In the 403B plan context, sometimes you have legacy investment options that participants have chosen and they like. If you switch record keepers in order to keep access to some of the annuity products or other products that folks may want in that 403B plan, you may need to keep that legacy record keeper, at least for maintaining the options that you already have. So, it's going to be it's going to be interesting to see how the court addresses that issue. They seemed amenable to the idea of multiple record keepers possibly serving a positive purpose. But one of the nice things about the Supreme Court is that I can speculate, but they'll provide a decision. And once they give that decision, they're not final because they're right. They're right because they're final. So whatever they say will be the case.
Yeah, I love it in the sense that important case. We're talking about ERISA, but also gives us a little bit of inside baseball as it relates to how the government works, specifically judiciary. Kevin, I want to take a very quick break. When we come back, we'll talk about more analysis and more key takeaways if you're a plan sponsor, or maybe if you're concerned about your retirement plan. You're going to want to stay tuned right here on BRN AM.
But if you're tired of the same.
Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings and retirement culturally relevant. But what do you see as a defining issue of the midterms, especially for the smaller businesses? I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network.
Are you stuck with a low credit score? A credit report and score that's causing you to be denied credit or pay higher interest rates than others for the same things? Then do what Terrence did and call Credit Repaired for your free credit evaluation to help restore your credit.
I started thinking about buying a new house, and my score wasn't where I needed it to be. I called and spoke with one of the representatives, and we just had a good conversation, and I liked what he was saying.
Just one call for his free credit evaluation was all it took to start back on the track to repairing his credit.
I'm seeing the deletions and I'm getting the report, so I know something's being done. It does make a difference to me.
All it takes is one call to get started.
Credit Repair has given me a second chance to have a better credit score.
Don't let a low credit score hold you back another day. Do what Terrence did and make the call for your free credit evaluation.
Call 800-819-4152. That's 800-819-4152. Again, 800-819-4152.
Welcome back. We're talking this morning to Kevin Walsh of Groom Law Group. Kevin, thanks so much for staying with us this morning.
No, happy to be here, and I'm glad that I didn't get cut between segments.
Yeah, no, that would never happen. I get cut before you get cut. So Kevin, let's talk about timing. Oral arguments that we're in the fall. It's currently December. When, in terms of timing, how long does the Supreme Court have to issue some type of judgment? Is it called a judgment or is it called a decision?
They'll issue their decision and then they'll issue a judgment. So their judgment, it's wonky. You know what? They'll issue both. That will when the decision comes out, we'll know what the judgment will be. But the big deal here is that the Supreme Court's a bit like a school in the sense that, everything wraps up at the end of the school year. Now, it's also a bit like a school that works on term papers, and you can turn your term paper in anytime you want. So the term of the Supreme Court will end, sometime in June, and then they'll go on a summer break. And what they do before they go on that summer break in June is they decide all of the cases from this term. So what we know is, it's December now. We can be confident that by the time June ends, they will have decided this case. I think they'll probably decide it before June, but we know that they'll decide it by the end of June. For folks who watch the court, what tends to happen is cases that are very controversial or cases where there's a lot of hot dissent between the justices. Those cases tend to drift until June because the justices will spend time, writing dissents, revising their opinion, trying to address the concerns of the other side, trying to make their positions clearer. Typically ERISA cases, don't cause quite the amount of heat as some of the other areas the Supreme Court addresses. So I'd be surprised if this is one of the last cases. But we'll probably see it sometime in the spring, early spring, I'd guess.
Kevin, key takeaways. You talked about some of them in the first segment, but if I'm, and you just outlined some of the timing of when we could get a decision/judgment. Let's talk about things that I should be doing as a fiduciary. You're in those board meetings all the time with many different entities representing the role of the fiduciary. What are things is it just document, but what are things that I need to be doing in consideration of what this judgment could be?
Yeah, so this is another case. I mean, it's part of a wave of fee litigation. And as we've said before, it's process. It seems as though one of the areas that plaintiffs focus on is, are there lower cost products available? In particular, are there identical lower cost products available? So if I'm a plan fiduciary and I haven't looked in a while, it might be a good time to, evaluate, are there new products on the market today by the manager that you're using that you are eligible for and that makes sense with your plan and their demographics that offer, an identical investment performance or an identical investment strategy and that are lower cost. It might be worth looking at that. If you have been with the record keeper for a while and you haven't conducted an RFI or fee benchmarking or an RFP in a number of years, it might be a good time to, look at this case and think, maybe I should go back to my record keeper, or maybe I should use an outside consultant and benchmark that, figure out if it makes sense for me to talk to my record keeper about, potentially finding a way for, to get a lower cost there. And then, based on the arguments here, I think, we saw the plaintiffs allege, this plan has too many investment options. Now, who knows how the Supreme Court will rule on these things, and too many investment options may not be a bad thing. It might be fine. The Supreme Court could even come out and say, 40 options is way better than 20 because it gives participants so much more choice. But if you're a plan fiduciary and you're looking at your lineup, it might be worth taking a look at your lineup and saying, what purpose do each of these options serve? Do I have holes in my lineup? Do I have things that are competing for the same investment strategy in my lineup? And does the lineup as a whole make sense? Yeah. So, to me, those are the three big areas where, a plan fiduciary might want to begin evaluating things today. But a lot of that really just relates to, what are we seeing out there that plaintiffs are alleging? It doesn't mean it's right or wrong. It just means that these are the types of things that plaintiffs are focusing on. And then by June, we'll have a better idea about, if any of the things that I described really are things that you really need to be doing. Because hopefully, one thing I like is when there's clear rules and clear guidelines. And the Supreme Court is having a great opportunity to give plan fiduciaries clear guidance about what they ought to be doing when they think about plan investment lineups.
Kevin, last question. Regardless of where this comes down, would you expect more litigation to continue? If this is, for example, they say, nope, none of this applies. It seems to me like, and I'm not an attorney, but the plaintiff's attorneys are going to look for different niches or nuances that they can continue the conversation. So would you expect litigation to continue regardless?
So I think there's a range of outcomes here. As I mentioned, I think Justice Roberts and Justice Kavanaugh expressed concern about the number of fee cases. If they provided a clear win for Northwestern, it could deter some of the fee litigation cases and maybe really encourage the plaintiff's bar to focus on cases that are strong as opposed to focusing on quantity. So you could have a clear win for the defense, which may reduce the total number, even if there will probably still be some. On the other hand, you could have a clear win for the plaintiffs, which would really encourage them to bring more of these cases. And then one of the great things about having a Supreme Court addressing a number of issues, you could have a bit of a split decision. And at that point, it'll take some time to really dig into, why they held the way they held, what exactly they said, and then try to understand the nuance of how that's going to impact fee litigation on a going forward basis, because there's a whole host of outcomes here, and each is going to have a different impact on the plaintiff's bar and the likelihood of success, or whether the defense bar is more successful.
Well, it's going to be interesting to watch. And as you said, if you're a fiduciary, document, go through these decisions on a regular basis so that you're not caught off guard and you have a very clear roadmap of the work that you have done and continue to do. Kevin Walsh, always a pleasure chatting with you. Thanks for breaking it down. And we look forward to having you back on the program again very soon.
Oh, thanks for having me on. It's always great. Thanks, viewers.
That wraps up this episode of BRN AM. Have a topic of interest, someone you think we should talk to, drop us a line. And don't forget, for all the information in retirement markets, technology, personal finance, so much more, all in one place, check out today's edition of our daily newsletter, The Morning Pulse. Want to see our latest content or search our archives? Check out our streaming partners like Roku, Amazon, and Samsung TV. We're back again tomorrow. Until then, I'm Jeff Snyder. Stay safe, keep on saving, and don't forget, roll with the changes.
Waiting here for you to take and drink of. But if you're tired,
Now is your opportunity to co-create content around any topic on the First Lifestyle and Wellness Network. Reach a global audience through our platform and co-own exclusive branded content. All of our programs are available on demand and also as audio-only podcasts, so you can take us on the go. Broadcast Retirement Network, available anytime, anywhere, and on any device.
Are you being audited and do you owe the IRS $10,000 or more in back taxes? Is the IRS threatening to take more of your money? Don't fight the IRS alone. The Tax Doctor is here to help you negotiate your tax bill and reduce your stress. The IRS can freeze your assets and seize your bank accounts, but you can stop these IRS actions. The Tax Doctor will work with you using our years of experience to represent your case to help you get the best resolution under the IRS guidelines. Help is here to deal with the IRS to reduce your stress. We've handled thousands of cases, so we know what we're doing. If you owe $10,000 or more in back taxes, do not call the IRS alone. Call a Tax Doctor now for a tax emergency analysis.
Call 800-224-6439.